Ladies and gentlemen, listeners around the world, welcome to the podcast series Creditors Corner Legal Talk, presented by Debnam, attorneys at law, where we explore a range of legal topics impacting businesses and individuals. Be sure to subscribe to stay up to date when our next episode releases. My name is David Belisle, and I'm an attorney with the firm's Creditors' Rights litigation section. Today's topic is sovereign citizens. What are they? Where do they come from? How are their actions disrupting businesses, government agencies, and the legal system? What is being done in response to the sovereign citizen movement? All these questions will be answered in today's podcast. Joining me today is attorney Caren and Enloe, a partner and practice group leader at Debnam with decades of legal experience in protecting creditors and lenders, also fighting for clients in the consumer financial services sector. Caren's practice encompasses the entirety of consumer finance litigation in both state and federal court, while also advising on compliance measures for businesses within the consumer finance industry. Caren's article titled Sovereign Citizens in the Raging War of Paper Terrorism was recently published by the Conference on Consumer Finance Law in its most recent quarterly report. This is the 2025 Volume 78, Number 3 issue. Before we continue any further, I must inform any listeners the information provided in this podcast does not and is not intended to constitute legal advice. Instead, any and all information or opinions shared are for general, informational, and entertainment purposes only. Listeners should contact a licensed attorney to obtain such legal advice. Now we can turn our attention back to the topic at hand for this episode, sovereign citizens. As I said previously, we are joined by attorney Caren and Enloe. Caren, thank you for taking some time out of your schedule to join us today to discuss sovereign citizens, and congratulations on having your article published by such an established and well-respected journal.
Thanks, David. It's great to be here.
All right, Kayla, I'll start off with the easy one. What the purpose of that we're here for today is, what is a sovereign citizen?
So, David, sovereign citizens have been around since the late 1800s in the form of tax protesters. We used to call them freemen. I think the FBI has defined them best, though. It's defined them as being anti-government extremists who believe that even though they physically reside in this country, they are separate or sovereign from the United States. As a result, they believe they don't have to answer to any governmental authority, including courts, taxing entities, motor vehicle departments, or law enforcement. By the numbers, last numbers I have come from 2023, and at that time, there were estimated to be at least 33 established sovereign citizens groups with no less than 93 branches. And the Anti-Defamation League, which is one of the entities that is tracking the sovereign citizen movement, the other being the Southern Poverty Law Center and the FBI, estimates that there are close to 400,000 sovereign citizens living in the United States. Their weapon of choice is paper, lots and lots of paper, and they should be taken seriously. They've been identified by the FBI as domestic terrorists.
So I know you just said they've been around since the 1800s and they're involved in the FBI. Uh, can you provide us a little bit more information with how this movement has gotten around, how it gained traction, and as well a short summary or overview of their beliefs?
Yeah, that's those are great questions, David. Let's start with the beginning. You look back post Civil War, and you start to see the word sovereign citizen appear for the first time, really in the form of tax protesters. They didn't believe they should have to pay taxes. They really kind of arise in times of what one of my partners would call times of want and woe. In other words, times where there's financial crisis or political unrest. We saw them really start to take off during the 1970s, during the farming crisis, with the Posse Comitatus, which really kind of went back to the county being the ruler, not the federal government. Saw several standoffs with law enforcement in the 1970s with farming community. And then we really started to see it take shape in the form it's in today during the recession and during the mortgage crisis of the mid 2000s. I think my first experience with them was in the late 1990s, when they were going around as freemen and they were trying to explain how the credit card companies owed them money, not the other way around. Like I said, they really kind of rise up in times of want and woe, in times of financial crisis, in times of political unrest, and hence that's where we are today. Now, you add to that the fact that social media has taken off in the last 20 years, and now their word is spread through TikTok and YouTube videos as a debt avoidance scheme. When we look at their beliefs, we really start to kind of look at a couple of common tenets. And for the attorneys out there, you see these references to all caps spellings and things like that. Well, this all goes back to when the US went off the gold standard in the 1930s. Um, the sovereign citizens believed that the person was split into two people. A straw man who was created through the birth certificates. And if you look at your birth certificate, David, I bet it's in all caps. That's the straw man, okay? The sovereign citizens believe that the U.S. pledged the straw man, the all caps person, an exemption account to identify by their social security number. This all starts to make sense when you start to look at some of what they do with international bills of exchange and everything else. That's where the money's coming from for those. And then there is also the person itself. So when you see them start to sign powers of attorneys for themselves, they're really they're writing a power of attorney for themselves because they're two people. There's the straw man and the real person. And so you that's kind of the start of the whole thing goes back to when we went off the gold standard. Um, and so they don't believe that when you look at the Constitution, because the Constitution says that states are only required to accept and recognize gold and silver as legal tender, they don't believe money is legal tender. So if money is lent in the form of dollar bills and things like that, they don't believe that's real money. So that's kind of how it all gets started, and that's kind of the genesis for all their theories. It really goes back to when the US went off the gold standard.
Thank you, Karen. I think that's a great summary of their beliefs, especially stemming from times of crisis to picking up traction within social media. Now, if I'm a creditor or a lender and I am trying to pursue recovery on a debt, how do I know whether or not I'm dealing with someone who's a sovereign citizen?
Well, first thing to know is that most sovereign citizens disavow their association with the sovereign citizen movement. And that's because there's so much case law out there talking about sovereign citizen theories. Now they're trying to disavow themselves as being sovereign citizens. So they'll deny that they're sovereign citizens. Secondly, if you see something that refers to the person as flesh and blood or as a vessel, or you see fingerprints as stamps, or you receive an international bill of exchange issued by the US Treasury and Janet Yellen, um, um, and predicated on unit trial, you're dealing with a sovereign citizen. If you're getting reams and reams of paper from an obligor on a debt, you're probably dealing with a sovereign citizen.
So, Karen, when I am in a lawsuit and I get a response that has multiple UCC claims and other federal statutory claims that I think have nothing to do with my lawsuit, such as a bill of exchange. Are those typical filings that you see with the sovereign citizen?
Those are exactly the filings that we see with the sovereign citizen, David. And look, their weapon of choice, as I said when we started, is paper, right? They're paper warriors, and so you're gonna see so much paper with them, it's gonna be crazy. You're gonna see a lot of UCC filings where they are now issuing themselves a lien. You're gonna see false money instruments being sent to the creditor. Um, you can see reams and reams of paper, and that's before the lawsuit's even filed. A lot of times, like in auto finance, they'll send a check, and I'm using air quotes you can't see online, um, to the creditor to try to satisfy it, or they'll send a lien or something, a UCC to the creditor. And so that's before they even file suit. Once the creditor files suit, then what you're going to see are a whole lot of things that look like law. UCC claims, citing UCC sections, copies of those checks being brought in, all kinds of things along those lines, legal phrases being thrown around, statutes and treaties that are being thrown around that aren't necessarily in effect in the United States. RICO and criminal claims being thrown into a civil lawsuit. All of these things are a sign of a sovereign citizen.
In my personal experience in practicing, I've also seen that, like you said, prior to lawsuit, you'll see sovereign citizens file things within the Register of Deeds or other UCC filings that really have no basis to be filed, yet are filed anyways. So I'm kind of leading into my next question, which is why is this movement so problematic for creditors, lenders, and others?
Well, because of the paper. When you get in your let's start within you're in a lawsuit, and they will file multiple filings, pages and pages, 35 page um treatises, and motions. And the problem that you have is they're almost always pro se. And if they're pro se, courts are generally going to give them much more, leash than they might give an attorney, and these claims look real, and so it's incumbent upon the attorney then to go into these claims and really parse them out. The good news is, over the last 20 years, there has been a lot of case law that has developed that debunks these theories, and I would encourage any attorney dealing with these that they go in and really review the case law on it to determine, what is out there that really explain it to the court, to bring the cases that debunk the theories into court, to explain to the judge why these claims have no bearing. Regarding the UCCs, most states have a UCC gatekeeper provision in place to a certain degree, and there are actions that can be taken under the UCC for false UCCs being filed. But again, that takes time and attention and money to do. And so that's why it's so problematic for creditors and others.
So it sounds like with all of these filings, and it sounds like they're throwing whatever they can at whatever avenue they also can find to try and ease out some way to either get out of paying the debts that they owe, or even trying to create their own cause of action for their own right to recover some monetary damages in some form or another. So, being this massive volume of filings that you see, what is their success rate with their claims?
Daily, I've never seen one granted. I mean, I put it at 0%. The only thing I have seen, and this is why I encourage creditors to take it seriously and, be vigilant, is we have seen sham arbitrations come up. And by sham arbitration, I mean by an arbitration association that's not recognized, by the courts, where there is a sham arbitration proceeding, there is a sham arbitration agreement that has been drawn up that the creditor has not agreed to, go through an arbitration proceeding. And I've seen one case out of somewhere in the Southeast, I can't remember where there was a motion to confirm that arbitration award, and because the creditor did not take it seriously and ignored it, the arbitration award got confirmed. But aside from that, 0%. Um, the good news is the courts used to just kind of uh, hold their nose and treat it with disdain. They're now starting to write some pretty measured and detailed opinions that really debunk these claims. And that's where I think it's really helpful for the attorney to go pull that law when they see things like UCC 1-318 cited, or 3108, and they see all these provisions being cited and these statutes being cited, like the KS Trust Act, I believe it is, which is, by the way, not been adopted by the US. Unique trial not adopted by the US. Lots of things like that that they are talking about that have just simply not been adopted by the US. The Hague Convention has nothing that is relevant to collection, but it's cited. Admiralty law being cited because you're a human vessel. Again, shut down by the courts.
Yeah, Karen, I know that in some of the experience that I have, a big red flag for me is I'll see someone filing their document and closing it with a cite to UCC section 1-308 and using such words as without prejudice or under protest or something of the like that is also insufficient. But you said, and I want to highlight on this, that creditors need to take it seriously, some of these claims, because they should expect for multiple filings where their weapon of choice is paper, the sovereign citizen weapon of choice being paper. So, can you talk just a little bit about how creditors should handle sovereign citizen claims?
Well, let's back up and talk about 1308 because that's a really good example that you just gave, David. And this is a provision of the UCC that's basically a reservation of rights. When that's being used with words like without prejudice or under protest or things like that, what the sovereign citizen is saying is, I'm trying to excuse myself from anything I might perjure myself with. And so, in other words, I'm giving myself a pass to not tell the truth. And so, when you start looking at those sections, that sounds good, 308, but when you start looking at what it has no relevance. It's not a quasi evidentiary tool that they try to use it for. So things like that, what a creditor should be doing other than just taking it seriously is really kind of debunking the claims, providing case law to the court, responding to the claims. If they get one of these bills of exchange checks to pay the entire amount of the debt, send it back. If they get a 1099, explain to the consumer that that is tax fraud. Try to, in other words, and it takes time and effort and money to do that, which is not particularly great. But at the same time, what you're getting is you're setting boundaries. And for some of these folks that don't really understand, that might be all it takes.
Okay, I've got one final question for you. What are the risks of not taking it seriously or not hiring a counsel that's dealt with these sort of claims before? And just really the ultimate question is, what is the consequences of just not taking some of these filings seriously?
Well, I mean, not responding is always a problem. If you've got a sovereign citizen who's filed a complaint and you don't answer, you're gonna have a default judgment taken against you. I do think creditors, for the most part, take it seriously. I do think creditors respond appropriately. I don't think it takes a special type of attorney to handle these claims. It does take an attorney who's diligent, that is looking at the claims, unraveling them and going ahead and understanding and looking at the law that has now been developed on these sovereign citizen theories, and they have been held by the courts to be frivolous.
In this case law, you've seen it both developed in both state and federal courts.
Yes, but primarily it's in the federal courts, believe it or not. And the reason that is, David, is you don't get a lot of published state opinions. It generally has to go up to an appellate level to get there. Having said that, there is some, but it is primarily coming out of the federal courts where every opinion is published, either in a publishable form or it's published on an online Lexis or Westlaw type document. So they're available to the public.
Karen, as we close out the episode, I want to thank you again for taking the time to provide us with such valuable information surrounding sovereign citizens. I know that myself, I've learned a lot during this discussion, and I'm sure that our listeners have also gotten some of their own key takeaways. If we have any questions or want to seek the legal counsel of you or any of the Smith Debnam attorneys, where can we find you?
I'm, at Enloe, CENLOE, at Smith Debnam, DEBNAM, law.com.
And listeners, you can also find us at our firm's website at smithdebnamlaw.com. That's SMITHDEBNAM law.com. And we thank you all for listening. We hope to see you in the next episode.